President, head of the Indian state, Article 52 to 78 in the Part 5 of the Constitution. Then election of the President. President is not directly elected by people. Elected members of both the houses of parliament, elected members of legislative assemblies of the state, and the elected members of legislative assemblies of Union Territories of Delhi and Puducherry take part into the presidential election. Note: nominated members of both the houses of parliament, nominated members of state legislative assemblies, state legislative councils in case of bicameral legislation, and nominated members of legislative assemblies of Delhi and Puducherry do not take part into presidential election. Also, where assembly is dissolved, members are not allowed to take part in the presidential election. Now, to maintain the uniformity between the state as well as parity between the state as a whole and the union, the value of one vote of MLA is equal to total population of the state divided by total number of elected members in the state legislative assembly. Similarly, value of one vote of MP is equal to total values of votes of all MLAs of all state divided by total number of elected members of parliament. Then election is in accordance with system of proportional representation by means of single transferable vote, and voting is done by secret ballot. Then candidate to be declared elected has to secure fixed quota of votes, and how quota is decided. The electoral quota is equal to total number of valid votes divided by total number of candidates to be elected plus 1, and to balance the equation plus 1 above. Okay. All doubts and disputes regarding the presidential election are decided by Supreme Court, whose decision is final. If election is declared void by the Supreme Court, then the decision taken by the presidents are not invalidated. Then what is the qualification for election as a president? President should be citizen of India, should have completed 35 years of age, should be qualified for the election as a member of Lok Sabha, and should not hold any office of profit. Then what is the oath taken by the president? To faithfully execute the office, to preserve, protect and defend the constitution and the law, and to devote himself to the service and well-being of people of India. Then who administered the oath? The oath is administered by Chief Justice of India, and in his absence, senior most judge of the Supreme Court. Then during his office, he is immune from criminal proceedings, and civil proceedings can be instituted against him during his office after giving 2 months notice. Then term of office of president is of 5 years, but he can resign before that. A resignation letter to be given to the vice president. He can also removed by the impeachment process for violation of constitution. Now, constitution does not define the meaning of phrase violation of constitution. Then what is the process of impeachment? The charges should be signed by 1/4 member of the house, and 14 days notice should be given to the president. And step 2, after impeachment resolution is passed by the majority of 2/3 of the total membership of the house, it is sent to the other house, which should investigate the charges. Step 3, if the other house also sustains the charges and passes the impeachment resolution by majority of 2/3 of the total membership house, then president stands removed from his office from the date on which resolution is so passed. Note: president has the right to appear and to present at such investigation. Also take this in consideration. Nominated members of either house of parliament can participate in the impeachment of the process, but elected members of legislative assemblies of the states and Union Territories of Delhi and Puducherry do not participate in the impeachment of president, though they are participate in this election. Again, if the office falls vacant by resignation, removal or death or otherwise, then election to be filled the vacancy should be held within 6 months from the date of occurrence of such vacancy. The vice president acts as a president in case of vacancy, and if vice president office is also vacant, then it is the Chief Justice of India act as a president. Then there is the veto power given to the president. Okay. Before that, if the bill is presented to president, he has 3 alternatives. He or she has 3 alternatives: to give assent, to withhold assent, or to return the bill. Now, what is a veto? There are veto powers. There is an absolute veto, qualified veto, suspensive veto, and pocket veto. Absolute veto, that is withholding assent to the bill passed by the legislature. Qualified veto, which can be overridden by the legislature with a higher majority. suspensive veto, which can be overridden by the legislature with an ordinary majority, and pocket veto, that is taking no action on the bill passed by legislature. Now, Indian president has only 3 vetoes, that is absolute veto, suspensive veto, and pocket veto. There is no qualified veto for the Indian president. It is only possessed by American president. Then, president under Article 123 of the Indian Constitution has power to promulgate ordinance. Ordinance has the same force and effect as the Act of Parliament, but are in nature of temporary laws. And when can ordinance can be promulgated? When both the houses of parliament are not in session, or either of the two houses of the parliament not in session, or when any one house is in session. Then ordinance making power falls under judicial review. And what is the validity of ordinance? If ordinance is approved by both the houses, it becomes an act. If the parliament has taken no action on the ordinance, then it expires the 6 weeks from the reassembly of the parliament. Then ordinance may also cease to operate even earlier if both the houses of parliament pass resolution disapproving it, and president can also withdraw an ordinance at any time. Then ordinance, like any other legislation, can be retrospective. It can modify, repeal any act of parliament or another ordinance. It alter or amend a text law. However, it cannot amend the constitution. Then, as per the rules of the Lok Sabha, whenever ordinance has to be placed in the House, the statement explaining the circumstances that necessitated immediate legislation by the ordinance should be placed before the House. Then, President has one more power, that is under Article 72 of the Constitution. President is empowered to grant pardons to the person who have been tried and convicted of any offence that may be against union law, court-martial, or sentence of death. Then what does pardon mean? Pardon means remove both the sentence and the conviction, completely absolves the convict from all the sentences, punishment and disqualification. Then commutation. It denotes the substitution of one form of punishment for the lighter form. And remission. It implies reducing the period of sentence without changing the character. Respite. It denotes awarding a lesser sentence in the place of one originally awarded due to some special fact. For example, physical disability. Reprieve. It implies a stay of execution of sentence, especially that of death, for a temporary period. Thank you, and please subscribe.